Afternoon, everyone. We're going to give a few minutes for everyone to sign in here before we get started. It's not quite noon. All right. Hello and good afternoon. My name is Mike Razor. I'm a partner with Kavich, Famlow, and Durkin in the Business, M&A, and Real Estate Department. We welcome you to this webinar where we are going to go through the Corporate Transparency Act. And hopefully after this webinar, you've got some working knowledge of it. And we're going to try to cut to the chase quickly without much ado because we know your time is valuable. I want to quickly introduce my firm and my team. Kavich has been around for about 140 years. We are known to have a pretty solid reputation in business, civil litigation, real estate, and estate planning. The folks you hear from today are from across those disciplines, so you can have a multidimensional look at the Corporate Transparency Act. Our typical clients are small to mid-market companies and individuals whose estate plans we do, families, family-owned businesses. And here is our team. I'll be joined today by Amanda May, Angela Fernanding, Eric Sarmiento, and Morgan Schweikhofer. Amanda and Angela are in our estate planning department. Eric and I, along with Morgan, are business attorneys, and Morgan does some litigation also. And without further ado, here is Morgan Schweikhofer, who's going to give you the overview of the Corporate Transparency Act.
Thank you, Mike. Hi, everybody. My name is Morgan, and what I'm going to kind of be talking about here is some just general background information on the Corporate Transparency Act, what it is, why it's being implemented, and what its purpose is. After that, we're going to kind of narrow down into the specifics a little bit with the subsequent presenters here. So what is FinCEN? The Financial Crimes Enforcement Network. Hopefully you or your client don't have too much of a intimate familiarity with this division. This is from the Bureau of the Department of Treasury. And its goal is essentially to enhance national security by collecting, analyzing, and sharing financial intelligence, as well as utilizing financial authorities to protect, the nationwide financial system from any misuse or money laundering. This act was enacted in 2021 through the National Defense Authorization Act, and this act can be found in Division F, where it essentially reiterates its goal of enhancing transparency to entity structures and ownership, and to combat, like I said, money laundering, tax fraud, and other illicit activities. Let's see here. So what is the purpose? As I said, the Act's primary purpose is to fight illegal financial activities. And their goal here is to create a registry of individuals who control legal entities so that law enforcement can more effectively identify and prosecute financial crimes. As some of you are aware, it's very easy to set up entities. Certainly in Ohio, you can set up an LLC in about the same time it takes to brew a cup of coffee. So the goals of this is to really kind of discourage shell companies as a tool to, move illicit funds. Many states don't require any sort of corporation or other entity to disclose information about their ownership in this sense. And therefore, Congress essentially determined that federal legislation would be necessary to collect and then provide this information accordingly. There are penalties for failure to comply, and they're not just civil. There are criminal penalties associated with not complying with this act. You're looking at substantial fines and even up to 2 years in prison. So one of the things that we're really trying to get the word out is the importance of this act and how it's really going to impact millions of businesses, so they're aware of what they need to do to be in compliance. All right, so who will this impact? This is going to impact what's called a reporting company. There are essentially two types of reporting companies. You got your domestic reporting companies. These are your LLCs, corporation, LLPs, any other entity that's created by filing a document with the Secretary of State or similar office. So for Ohio, the Ohio Secretary of State's office. You also have foreign reporting companies. These are entities formed outside of Ohio, in this specific example, that are registered to do business in Ohio. We have several, entities that form in Delaware due to favorable business laws there, and then register to practice their business elsewhere in the country. So that would be qualifying as a foreign reporting company as well. So some examples here include, even single member LLCs, limited liability, limited partnerships, limited liability partnerships, corporations, business trusts. There are some exemptions that we're going to go over here in a minute, but this flow chart kind of gives a demonstration of, answering the question, is your entity going to have to be a reporting entity under this act? If it's a corporation, yep, it might be an LLC. It might be created. Most likely it's going to be a domestic reporting company. If it's outside the state, it might be foreign. However, again, foreign reporting companies still are under the obligation to report. All right, so there are some exemptions that from reporting under this act. There's 23 different types of entities that are typically in pretty heavily regulated industries. The reason these companies are exempt is they already have pretty lengthy reporting requirements. I know the SEC, especially with financial institution, has a pretty extensive list of reporting requirements. So the government essentially theorized they are not at a risk for being a shell company because all of the information that this act needs is probably already on file for these different types of entities. So here are just some of the exceptions here. You have, 501c3s, publicly traded companies, and I think two of the most common ones that you'll see are dormant entities and a bona fide operating company. So a dormant entity, think of a holding company that served its purpose years ago and has just been kind of sitting there stagnant for many years. This company is not engaged in a business. It's not owned by a foreign person. There's no assets, there's no transfer of funds, no change in ownership. That would be considered a dormant entity. A bona fide operating company is also a company with over 20 employees, more than 5 million in gross receipts in the previous taxable year, and there's a physical office in the United States. So essentially quite the opposite of a dormant entity. So specifically, these are the list of 23 exempt entities from reporting. And I won't go through all of them, but I will touch on a couple of them here. You can see that credit unions are exempt, and this does include both state and federal credit unions. Excuse me. You can see investment company or investment advisors. These are any entities that are defined in the Investment Company Act of 1940, or as Section 202 of the Investment Advisors Act of 1940, and are registered with the SEC under same act. You have insurance companies down here, number 12. This is, any insurance company as defined in Section 2 of the Investment Company Act of 1940. We have insurance providers. We have accounting firms. Accounting firms are technically defined as any public accounting firm registered in accordance with Section 102 of the Sarbanes-Oxley Act of 2002. Public utilities, tax-exempt entities, and then entities assisting a tax-exempt entity. This is technically an entity that operates exclusively to provide financial assistance to or hold governance over any entity described in number 19, a tax-exempt entity. We went over the bona fide operating company and then also included our subsidiaries of certain exempt entities. So number 22 here, subsidiary, is any entity whose ownership is controlled or wholly owned, directly or indirectly, by one of the more entities described in these above exceptions as well. So to determine here whether or not you're filing your reporting company for purposes of this act, you need to determine if your entity is a corporation, LLC, or other entity that's created by the filing of a document with the Secretary of State or similar office, or if it's formed under the law of a foreign country or a state and registered to do business here. And once you decide if you fall into that category or not, then you have to look and see if one of these 23 types of entities are something that you are considered for purposes of exemption. So that's what we have there. And I am now going to turn this over to Eric Sarmiento, who will be getting into more details about the beneficial ownership reports.
All right, thanks, Morgan. So I'm going to talk about what actually gets filed with FinCEN. Dub them these beneficial ownership information or BOI reports. They get filed ultimately with on the beneficial ownership secure system or the BOSS system, which is maintained by FinCEN. It's expected that this submission process will be similar to what is currently in place with the SEC and its EDGAR filing database, but it's not yet live, or there's no ability that I think is available to us to try it out to see how it would work. But ultimately, it's going to be taking submissions of these BOI reports, which would include certain information about the reporting company itself. If you qualify, as Morgan discussed, the reporting company's beneficial owners and its applicants. So the information about the particular beneficial owners and applicants that will be on these BOI reports would be the owner or applicant's full legal name, their date of birth, their address, a state issued ID number, or that would be a government issued passport or driver's license, along with a photocopy of that document. The BOI reports themselves and the information that goes along with them are considered sensitive information. They're going to be kept confidential, except for access by certain governmental authorities and authorized financial institutions. So if your bank or lender wants to see your BOI report, they can if you give them authority to do so. So again, given that this information is only accessible to government authorities and certain financial institutions, doesn't necessarily mean it's impregnable from hackers or bad actors who may otherwise try to access it. It's considered very sensitive information, so the government will, to the highest of its ability, protect this database of with this information, which would be very valuable. But again, as with other information leaks and attempts to access secure data, I don't think it's necessarily guaranteed. But just a thought there. So when we talk about who or what information is on these BOI reports, it requires to disclose information about beneficial owners. So I'm thinking about what or who is a beneficial owner. It would be any individual who directly or indirectly exercises substantial control over the entity. So a senior officer or manager of, say, an LLC or a corporation, or an individual who owns 25% or more of the ownership interests, which are broadly defined in that reporting company. So on the BOI report itself, the reporting companies aren't required to disclose why a beneficial owner qualifies, whether it's through ownership or substantial control. It's just enough that the determination is made by the reporting company that this individual is a beneficial owner and has to be disclosed on this BOI report. Again, there's not necessarily a maximum number of beneficial owners that may require to be reported either through ownership or having that substantial control component. So depending on the entity, could wind up being a lot of people unless you qualify for an exception or an exemption, as Morgan discussed earlier. And there is an ongoing obligation to update the BOI report within 30 days after a change is made. So if the entity is sold or an interest in that entity is sold to someone else that's over that 25% threshold, you'd have to file an updated BOI report, or within 30 days after you become aware that information that was previously reported is inaccurate. So aside from the updates, this implicates more than just the BOI report itself. Thinking about the governing documents for, say, an LLC, an operating agreement, we should consider if you have certain individuals or owners who would qualify through control or ownership that maybe don't want to provide their name or a copy of their passport or driver's license. You'd have to think about including provisions in the operating agreement that would either require that, give the company the ability to withhold distributions to that individual if he or she is unwilling to provide that information, because the penalties, both civil and potentially criminal, for not following the Corporate Transparency Act can be significant. So the other prong of who might qualify if they don't otherwise have that ownership component is through substantial control. So here are a few kind of points to think about as to who may be substantial control, who may have substantial control over the entity or reporting company without necessarily having any ownership. So again, senior officer, individual who controls a majority of the voting power or voting rights, whether incident to ownership or not. If the individual has representation or is allowed to designate representation on a company's board of directors or board of managers. Again, this is not a non-exclusive or a non-exhaustive list of substantial control reasons that might require someone to be disclosed on a beneficial ownership report. But again, things to consider that it's not just enough to look at the ownership component, but also consider who might have substantial control over an entity as well. So again, someone who has the ability to make important decisions on behalf of the entity could be viewed as having or being able to exercise substantial control over that entity as well. So being able to sell, lease, mortgage, or otherwise transfer any of the principal assets of a reporting company could be viewed as having substantial control. The ability to decide on making major expenditures or investments on behalf of the reporting company as well. Also in terms of selecting business lines or ventures that the reporting company may elect to go into. So again, quite a bit to consider as to whether an individual or manager, even without ownership, might have substantial control over a reporting company and may need to be disclosed or reported on the BOI report as well. So again, thinking about the ownership interest, it is broadly defined. So not just owning, a certain class of voting stock, for example, but it could include profit interests, convertible instruments, options to buy or sell any of those types of equity or interest in the company. And this can be further complicated by reporting companies having multiple types or classes of ownership interests. So if you have a structure where it's unclear, typically would want to err on the side of reporting that individual or making sure their information is provided on the BOI report. But again, it's not necessarily going to be an easy evaluation in all cases as to determine whether someone is going to have to be reported due to their ownership interest in a reporting company. So for example, trusts, which Amanda, my colleague, will touch on more later, that individual trustee, maybe it's an attorney or someone who otherwise doesn't have any beneficial interest in the trust itself, might have to be disclosed on a BOI report, depending on the authority that the trustee has. So for example, if that trustee has the ability to sell or dispose of trust assets, that trustee could be viewed as having substantial control over what might be a entity that would have to be reported on a BOI report as well. Again, not typically a lot of something we see a lot here in Ohio, I believe, but in certain states where trust companies do need to be filed or reported to that state Secretary of State, could implicate a filing requirement in terms of a BOI report under the Corporate Transparency Act. As with the exemptions for reporting companies, there are also exemptions as to who would not need to be disclosed on a BOI report, even though they may otherwise qualify as a beneficial owner. So minor children being one example, employees that are solely employees, they don't have that substantial control element or realized economic benefits from the entity either, and creditors as well would be excluded, among others, as beneficial owners. So the other kind of group of individuals that would have to also be reported on a BOI report would be the applicants, so who is actually filling out or providing the information into the BOSS system to complete the BOI report. So here there is a limit, maximum of 2 applicants who would be listed. So it's the person who would directly file the information with of the reporting company, and the person who is responsible for directing that filing. So for example, if I ask one of our paralegals to help file articles of organization to form an LLC here in Ohio, we would both be on the BOI report as the applicants, the one who directly files the registration document and the one who directed it. So and previously, there was the initial drafts of the Corporate Transparency Act a requirement that entities formed before January 1, 2024 would also need to provide information on applicants. That is no longer the case. For example, a corporation that was formed back in the 80s just seemed unmanageable, not feasible for an entity to kind of look back, figure out which attorney they used, if he or she is still around, get the information of a paralegal who helped file the articles. So that's no longer the case for entities formed prior to January 1, 2024, but going forward, that applicant information will need to be included on the ownership on the BOI report. Again, if that applicant information changes in the future, there's not a requirement to update that information on the BOI report. So for the company applicant, I've kind of touched on this before as far as the direct filer and the person who directs or controls the filing itself. So I'll skip over this one for now just to keep moving. And if you anticipate being sort of a regular filer, if you have several entities set up, or like an attorney like myself, I anticipate having to file or help directly file what would end up being a reporting company. Once you fill in the information on a BOI report initially, whether as a beneficial owner or an applicant, you can obtain a FinCEN identifier number. So you don't have to keep every time uploading a picture of your government issued ID, your name, address, so on, to help streamline the process in the future. So if you do anticipate that, we would recommend looking to get that FinCEN identifier number after you initially file. So that concludes my portion of the presentation, and turn it over to my colleague here, Amanda May, to talk about the impact of the Corporate Transparency Act on trusts.
Thanks, Eric. So yeah, I'm going to dive into the Act on trust. I'm an estate planning attorney, and so when this all came out, my first question was how would it impact trust, especially considering that trust oftentimes follows legal. Before I jump in, just as an aside, if you have any questions, feel free to type them in the Q&A section below, and we'll get to those at the end. Okay, so trusts generally are not included as entities that have to report because in part, trusts are not required to be filed with the Secretary of State. So when you think of companies that have to report, the first thing that should come to your mind is this entity required to report, it's required to be filed with the Secretary of State. If the answer is no, then generally they won't be required to report, but there's some exceptions to trusts. So when a trust owns or controls 25% or more of a reporting entity, or if the trustee exercises substantial control over a reporting entity, then they will be required to report. So I'll get into the specifics of that. Okay, so there's some main examples of when a trust will be required to report. The first that I see it most frequently is when the trust is an owner of, say, a family-owned LLC, a corporation, partnership. That's one of the times that a trust will have to report. So for this situation, think of someone who transfers their business into a revocable trust in order to avoid probate. There's a lot of reasons why business owners don't want to go through probate on their business and so one of those ways to avoid it would just be to move the entity into a revocable trust, and then that trust would now be required to report. Another example, think of a parent who transfers the business into a trust. The parent dies, and now the kids inherit a third interest in. There's 3 kids; they each inherit a third interest in this trust, which owns the LLC. Now the kids are going to have to report because they have an ownership interest in that LLC. Okay, and then another example, when an LLC owns a rental property for estate planning purposes, a lot of times we will transfer the LLC into the trust. And so think of a client who comes and says, you know, I own 10 rental properties. The first thing that any attorney is going to suggest is to get those rental properties into an LLC. And then we'll put the LLC a lot of times into the trust in order to avoid probate. 1 second, I was just told I have an echo. I'm not sure how to fix that. So Alyssa, if you can jump on and help me out with that, that would be great. Sorry, bear with me 1 second. Okay, I'm going to keep going while they fix this on the IT end. Okay, so another example, when shares of stock in a corporation are transferred into a spousal gift trust for estate tax planning purposes. So think of husband and wife who own shares in a company, and then husband will transfer oftentimes to wife's spousal gift trust. Wife will transfer to husband's spousal gift trust. Now that trust is a reporting entity, and they have certain requirements with the Secretary of State. Okay, and I'm going to jump to the next slide. 1 second. Okay. Okay, so the next question, who has to report under a trust? So the answer is always going to be a beneficial owner. So the next question is, who is the beneficial owner of a trust? So the first person is a trustee and any other individual with authority to dispose of trust assets. So some examples would be a trustee who controls distribution, the distribution of assets. So think of a trustee who has the ability to make discretionary distributions to beneficiaries. They would they would be a beneficial owner. A beneficiary who has withdrawal rights, so they can demand principal for a bunch of different reasons. A lot of times we'll put ages where someone is able to make principal withdrawals. Let's say upon turning 25, they can take out a portion of the trust. When they turn 25, now they have to report. Another example is the grantor settler that has the ability to remove assets from the trust. So this is going to be pretty much any revocable trust if the grantor is alive. So anytime someone has a trust for estate planning purposes, and that trust could be a beneficial owner if it owns an entity that's required to report. And then any individual who has veto powers over the trustee. This is a little bit trickier, but think of someone who's a trust protector, a trust advisor, anyone who can exercise control over the trustee. So if they can override decisions from the trustee, if they can remove the trustee, is there a group of people who can remove the trustee? Those are all individuals who are going to be considered beneficial owners. So just to note, this can be multiple people. This is typically, I can't really think of many situations where there will only be one beneficial owner, so just keep that in mind. Okay, and then another thing to keep in mind is ownership aggregation. The Act provides that the individual's ownership is going to be aggregated with trust ownership when determining if they own or control 25% of an entity. So I put an example in here. If a revocable trust owns 20% of a family partnership, and Sam, the current sole beneficiary, also owns 8% individually in his personal name, then you would take Sam's aggregate ownership, which would be 28%, and he would be required to report. So if he only owned the 8% individually, then he would not be required to report. If he only owned the 20% in the trust, he would not be required to report. But because he owns both, then he meets that 25% threshold, and now he has to report. Okay, and then changes that they would be required to report to FinCEN. A trustee, if they ever change addresses, they would have to report that. Same with a beneficiary. If a beneficiary ever has newly acquired withdrawal rights, that's going to be something to keep in mind. So like I talked about earlier, if a beneficiary reaches an age where she can now make her own withdrawals, she will have to be, she'll have to report. Or let's say she's given withdrawal rights for college education and she just started her first year of college. Now she's going to have to be required to report. So I would just say make sure you get the estate planning attorneys involved here as this becomes effective so they can take a look at the documents and determine who will have to report information. And again, this will only apply if the trust owns, has an interest in a reporting entity. So just keep that in mind. And then if there's a change to the trustee, trust advisor, trust protector. So think of if the trustee dies and there's a new trustee in place, if a trustee is removed, if they step down, any situation like that, that's where we see probably the most turnover in the trustee position. And so you'll have to report that. And then if a beneficial owner dies, so this could be a beneficiary or a grantor of a trust. So any kind of trust that's been held in the family for a long time, that'll be probably a key example of where you'll have a lot of different beneficiaries, some pass away and then others inherit. So that's all I've got for the impact on trust, and I will pass it over to Mike Razor.
Hey, man, it sounds like you're inside of an airplane. If you wouldn't mind going on mute.
Yep, you got it. Sorry about that.
No worries. So my part of the presentation is going to be about the mechanics of filing the report, timing of filing the report, rather, and then the practicalities of how it's going to impact business operations and transactions. Your initial BOI report, when it's due, is dependent upon when the company was formed. So all companies that are in existence as of today and formed up until midnight on December 31st have a full year to comply. They can, they'll have to comply by January 1st of 2025. If there's a company that's formed next year, it's a little bit in flux. I think you should plan on making your report within 30 days. But FinCEN has proposed a rule to expand that to 90 days while people sort of get acclimated to the software and get their reports in order, or get the information they need in order. And I think there's not really any question that if there's a company formed after 1/1/25, that will be subject to the statutory 30-day period. The other thing to keep in mind for deadlines is when you have to make a change to your report. And there's a lot of different reasons. I think Amanda touched on some of them as far as estate plans and trusts go. But there's also changes if a company basically becomes subject to the act, or in other words, it loses its exemption, or if becomes exempt. Those changes, those reports are required to be revised within 30 days of that change. Also, there's things that are going to happen in the course of any company that will cause that BOI form to be outdated. And some of them include, let's say you start a new division and you create a new DBA. Well, that's a BOI report amendment. Let's say that somebody goes from 20% to 30% ownership. That's a BOI amendment. You hire a new CEO, a new officer who has substantial control under the test that Eric laid out. There's an amendment there. So this just has to start to become second nature. Whenever something important happens, we think, what does this mean for the BOI report? I think that it's become sort of second nature for us to think, what does this do for our federal income tax purposes, for instance, when we have something substantial happen with our business. And now I think the CTA has to almost take that same footing, especially when you look at how steep the fines are. So I think by now we've kind of gone over the CTA, what it is, why it was enacted, whether your company is subject to it, and the report that will be filed. The most important thing I think that we'll all be thinking about in the next, over the course of 2024, is getting a strategy for all of those companies that were formed before 2024, and how we organize them, then organize the information that goes into those reports so that they're ready to go before 1/1/25. And some of the ways I've been thinking about how to capture all of the potential entities. Start thinking about what divisions of your company do you have. Every big transaction that your company has undertaken, your real estate assets, often they're in different LLCs, parcel by parcel even, and start thinking about that even personally. If you own your home in an LLC, it's got to go on the list. And of course, look at your tax returns. Another good idea is to have a conversation with your CPA to say, hey, this is my list of LLCs I can remember. What else do you have? And last, if you're a professional lawyer, oftentimes we're named as statutory agents. So you can do a reverse check of your statutory agent name on the Ohio Secretary of State site. If it's possible on Delaware, that should be done also. Maybe Florida, the main states that you ever form LLCs in. And then also, contact all the people who are relying on you for professional advice and say, this is something that's coming up. Don't procrastinate. Let's set up a meeting and start sketching out your web of organizational entities so we can do this. And so once you've got that list, here are some things that you can do to prepare for these reports. First, you're almost without question, if you're a business person who's been doing business for a few decades, you're going to have a lot of entities that aren't being used. So just go ahead and dissolve them, even if you're not you otherwise probably wouldn't do anything with it. You just let it sit, but dissolving it makes sure that you don't have any sort of questions about compliance with CTA. If you have multiple entities under a single reporting taxpayer. What I've been telling folks to think about is merging them into one LLC. An Ohio or Delaware LLC would either suffice, and creating that into a series LLC. So that if you're not familiar with the series LLC, it's a relatively new feature in Ohio law. It's been around for a couple decades in Delaware, where you have one LLC with multiple liability silos inside of it. So it's like having a parent company with subsidiaries, but it's all in one box. So if you do that, then you have you don't have 10 LLCs that all have to file beneficial owner reports, all have to make changes when the changes are necessitated. You have one, and if they have different ownership structures, that's not even a problem. You can have different economic rights and voting rights within the series LLC for each separate series. It's a longer conversation about the series LLC, but that's one mechanism that can be used. And also, once you've got your grips around how many companies you have to report, start asking for all the people's information. You're gonna need passports and all the stuff that Eric laid out. So don't wait till December of next year to do that. That's for sure. So I gave a longer presentation overseas in January on this topic. So I'll try to condense it into a few minutes here. But CTA is going to have an impact on business transactions. Our firm does a lot of M&A work, and we are sort of putting circling the wagons on how this is going to impact your routine deals. And I think there's going to be impact from several different angles. First of all, this might be considered as a positive impact, is that you can, in a transaction, ask the counterparty to give you their CTA BOI report. So instead of saying, hey, we see this operating agreement, it's signed, but we don't see the tax returns to verify the ownership percentages. We don't really trust these people, that the authority might not be exactly what they're professing it to be. One extra piece of information that is unlikely they'd be lying about is the BOI report. So you can request that, and as it was mentioned earlier, a lender can get authorization to get it directly from the government. CTA compliance can create liabilities, as we've talked about, and so in due diligence, I'd want to have some good, firm understanding of the level of compliance going forward. Or I mean, let's say you have a deal that's closing in mid 2025. I'd say on my checklist is going to say, it's going to ask about are the reports filed? Are they correct? And I similarly would have a representation and warranty inside the purchase agreement that says we've been filing them, they're correct, there's no trailing liabilities here. We've had to prepare some foreign companies that want to do business, European business companies that want to do business in the U.S. that this is coming, because they will have to comply with CTA also. One really important thing I think is that I touched on earlier. After you complete a transaction, once the smoke clears, you should immediately be thinking, what do I have to do to my BOI report? Let's say you acquire a business, or you merge, or you bring on a new partner, you bring on a new executive. These things are all going to require BOI report analysis, and almost certainly going to require a change. And don't let this surprise you. 3 months later, you wake up in the middle of the night and think, oh my gosh, we brought on Jennifer as our COO, and we never changed our BOI report. You got to have somebody in charge of this at your company, somebody who's always thinking about this. Of course, your lawyer is also hopefully going to be advising along the way also. And then just one little smaller trick, I think we doing transactions, sometimes we'll form a company that's going to be our buyer well in advance of the closing, and even probably before the purchase agreement is signed in some cases. I think CTA sort of incentivizes you to wait a little bit and maybe have a different company as your initial party, and then assign that purchase agreement to the new co that is recently formed closer to closing. And the reason to do that is I wouldn't want to file NewCo and then within 30 days have to file the BOI report and then close 45 days later, and then the buyer or you have to go amend that BOI report, which is probably something, you just don't want to. This goes together with merging and liquidating, dissolving companies. Reduce the opportunities to make mistakes, in short. All right, so that is our presentation. I want to thank all of you for attending. Hopefully you took a little bit away from this. All of the things that we learned, that we tried to express today are you're going to have to keep them in front of your mind as the next 13 months play out. And I will hand this off to Angela Fernending, who will take any Q&A.
Thank you, Mike. Going through the questions, there's one that's been asked a couple of times. I'll address that one first, and that being that yes, everyone will receive an email following the presentation, and included in that email will be a link where you can access both the recording and the PowerPoint slides. So hopefully that addresses a couple of them. The next question is from Cindy Kula. I hope I'm pronouncing that correctly. Should CPAs be concerned about filing these reports since it might be construed as unauthorized practice of law? And I think it depends on your role in dealing with the CTA. If you are simply submitting the report on behalf of your client, I think that's fine. But if it goes into more depth, where you're actually advising the client with regard to who should be named a beneficial owner, you probably need to get an attorney involved at that point in time. So does anyone else on the panel have any comments on that? Okay,
I'll say I think it is a valid concern, not necessarily the BOI report itself, that kind of as mentioned, the information that goes into it about the individual, whether the owner or someone in control, isn't very extensive. I think what it comes down to is making the determination, as far as whether the reporting company itself is exempt or not, and then who needs to be reported within that BOI report as the owner or individual who has substantial control. So as you get into more complex entity structures or ownership structures with more people involved, I think that determination becomes harder to make. So from information and materials I've read, I understand a lot of the larger accounting firms are referring BOI report issues and compliance to the client's law firms to help make those kind of determinations.
Thank you so much, Eric. That's a much better answer to that question. Now I have Doug Langshaw. He's asking whether or not the attribution rules of family members go into the 25% test or the control of the entity. And from what I have read, it does. So the CTA requires that an ownership interest by another person or anyone who has the ability to control, and they've adopted some broad language with regard to control. So I believe that any ownership interest that a family member does have needs to be aggregated with your own. And we also are really encouraging clients to err on the side of caution. It is better to over-report beneficial owners as opposed to leave out someone who should have been. There's no penalty for over-reporting in any way. So does anyone else have comments on that as well? Okay, we'll move on. This is Matt McGinnis. I understand that there is a pending lawsuit in the Northern District of Alabama brought by the NSBA versus federal government aimed at fighting the CTA. I have heard that it may delay the filing deadline. Any update on where this stands? And I will need to defer this question. Mike, do you have any information? Are you aware of this lawsuit in the Northern District of Alabama?
I'll say a couple words and I'll defer to Morgan, who I think is also tracking it. There was a hearing scheduled for November 6th, which is, let's see, this week, and then it got pushed to November 20th. This is a hearing on dispositive motions. So what you'd see next is the district court ruling on that, and then the loser appealing to the Circuit Court of Appeals, probably on the injunction, on the stay, and then that may go up to the Supreme Court. I mean, I wouldn't count on this being something you can that takes your eye off the ball here. It could happen, but I'm not putting a lot of faith in it. Morgan, do you have any contrary thoughts?
No, I think, this case is almost a year old, and I know that the NSBA, the Small Business Association, is alleging that the CTA violates a lot of constitutional principles, including unreasonable search and seizure. As Mike said, dispositive motions were filed, excuse me, and hearing dates have been kind of scheduled and rescheduled. The next one, I think, as you mentioned, on the 20th. So it'll be interesting to see what happens there, especially given the timeline. If this goes into effect January 1, 2024, and you're having a hearing on 11/20, that's really given the court a short amount of time to kind of look at all the issues and rule on this. So we're going to be monitoring it and kind of see what happens depending on how the court rules at that time.
Great. Thank you, Morgan. Thank you, Mike. The next question is, do you think reporting will be similar to BE10? I unfortunately am not aware of BE10 reporting. So is there anyone else on the panel that can address this issue? Okay. So if you could please add a little bit more detail into the Q&A, we may be able to respond to that at a later time in the Q&A. The next question is, can you provide practical tips for attorneys that have formed many entities in the past? And I believe Mike has covered that in his presentation with regard to how we are looking at actually the implementation of the CTA in our practice. And then finally, the last question is CTA reporting only one time or needs to be filed every few years? And as was discussed, the reporting needs to be corrected and adjusted based on change in beneficial owners. So anytime there's a change, within 30 days, the entity needs to update the reporting with the CTA, with FinCEN. So are there any other questions or any other comments that the panel wants to provide to our participants? If not, we recognize that there are many demands on your time, and we appreciate your taking the time out of your schedule to attend our webinar. So as I indicated earlier, you will be receiving an email, and it will have a link to the presentation, a recording, as well as the slides. There's also going to be a 3-question survey. You'll receive it when you leave the webinar, but there'll also be a link to it in your email. And if you wouldn't mind taking the time, 3 quick questions, we would truly appreciate it. Thank you so much. Have a great day, everyone.